That's why I walked up to me and said, I think this is alkalized. I'm like, well, it's mine now. All right, we got 1 minute.
Sue and Benny are on their way too.
Okay. I'll be here.
We're not in reserved seating.
No! Reserved seating?
I thought, it crossed my mind that there might be a reason the front row was empty.
It's because everybody's
Nobody likes to sit in the front row.
They go to church on Sunday, and the first rows are empty, and everybody's in the back trying to fill in the, nobody wants to be down front.
All right, everybody, welcome to my exclusively visual presentation with no sound and only captions. Hi, Sabrina. So I did something like that once, so I said, that's not right. And I'm going, you don't know
If you guys
Sabrina.
want to be down front, I can move down a little bit. There's 3 seats in the front.
Okay, sure.
I don't bite, I can.
Okay, got you, and then Ryan.
No problem.
You got him?
Yeah, he's down here.
Blind convoy, yes.
All right.
There you go.
And there.
Hold on. No. Yep.
I
did my chair math wrong.
We're going to do the guidance counselor pose today.
Careful on that hip when you do that, though.
Hello, everybody.
Hello, Boozy.
I am Boozy Badger. This is Basic Law for Idiots because you are all idiots. I'm attorney in the Commonwealth of Pennsylvania. I've been a licensed attorney for several years now. I'm admitted to the Commonwealth Courts of Pennsylvania, which means I can practice in every state level court. I'm admitted to the Eastern District of Pennsylvania's federal trial courts. I'm admitted to the Third Circuit, and I am pending admission to the United States Supreme Court. I am a lawyer. By the way, when I say the last one, I'm pending admission. Like people are like, oh, the Supreme Court, he knows it. Guys, you just have to practice 3 years and give them like $400. It's not a big deal. like we take bus trips to do this. So, the way that this is done, for the most part, as I start out, I talk about a couple legal principles, and then I wander around the room and I run this in kind of a Socratic method where I ask a question, I listen to your answer, and I tell you why you're wrong. Does anybody in here know what the Socratic method is? One person in the back, and it's Benny, so we're just going to act like he didn't raise his hand.
I'd take a guess, but I'd probably.
Here's the classic story. At Harvard Law, there is a library called the Widener Library. It's named after a former dean of the Harvard Law School. I did not go to Harvard. My father did go to Harvard, however, and he told me a wonderful story about when he was getting his tour of campus, and somebody said, and this is the Widener Library, named after Dean Widener, who invented the Socratic method for law school. May he burn in hell. The Socratic method is where we ask questions, we listen to your answers, and then we challenge you on your answers to get you to think. In law school, they do this by assigning you several cases to read each day. You read those cases, you go in, and a professor will stand up and say, Mr. Tiger, would you please explain the holdings of Stambovsky v. Ackley? And then you answer, and they go, mm-hmm. Does anybody have any commentary on Mr. Tiger's analysis of Stambovsky v. Ackley? And then you raise your hand, and they go, okay. And they turn back and go, now how do you reconcile? And this goes on for an hour, and you're the only one answering questions, and lawyers drink a lot.
Now we know why.
But I come in here, I did this the first time, somebody said there's not as much criminal stuff as I would like to hear, and there's a simple reason for that. And we are going to start covering some criminal law tenets. But the main reason is most of you are never going to experience a criminal court. I hope. If you do, call me. I can wave into Ohio pretty easy. The criminal system is completely different from the civil system. The way that our law is done here in the United States is we have two systems, civil and criminal. Criminal is you broke the law. Civil is you have hurt someone in some way or you have some other matter. If it's not criminal, it's civil. Family law, estate law, suing people, car accidents, all that's civil law. Criminal law is you got pulled over by the police and they said, do you have any drugs in the car? And you said, technically they're in the trunk. That's a real client of mine. The highlights of criminal law that you need to know are very, very simple. They're very, very boiled down. Number one, you have certain rights the moment the police detain you. That is a situation where you are not free to leave. All right, I know we have all seen the YouTube videos, am I being detained, am I being detained, taser, yes, I laugh at them too. However, they're asking a very good question because they don't have to tell you. if you're being detained or if you're free to leave at any point during the encounter. If the police stop you, they walk up to the car and they say license and registration, and then they hand you a ticket, they'll walk off, they'll turn around. This is a real common thing. All right, sir, thank you, have a nice day. Hey, you know what? I was just thinking. Do you have anything in your car I need to know about? All right. Now, at that point, can you leave?
He's already told you to leave.
Why can you leave?
Because you already got the ticket and finished the.
That's actually completely correct. All right. You were being detained, and that's an important question. The Fourth Amendment rights. All right, that is your right against unlawful search and seizure of your property or person. Only apply when you are in a situation where you cannot leave. Like if a cop stops you and says, "You got a gun in your pocket?" Are you detained?
Yes.
No.
No, because he hasn't told you that.
That's a consensual encounter. And those are really different things. The police we call them knock and talks. Hi, we're just in the neighborhood meeting the residents, and oh look, you happen to have marijuana on your coffee table. Please open the door. Anything wrong with that?
No more.
Visual, I mean, it's visualized, they see it.
That's actually right. It's called the plain view doctrine, but the question is, what about the initial knock? Is that an unreasonable search or seizure?
No,
You don't have to open the door.
Yeah.
that's true.
Right there. Now, it sounds particular. Like you go in, you're sitting in a police department, they've asked you to come in to talk to them because maybe you have information on a crime they're investigating. All right? And about halfway through you think, you know, maybe I want to have a lawyer here. And they say, no, you don't need a lawyer. So where were you that night? All right, now remember, you've heard the Miranda rights, correct?
Mm-hmm.
All right, do you know them? You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questioning. If you cannot afford an attorney, won't be provided to you, all that. You have the right to an attorney. You said, maybe I want to have a lawyer. And the cop ignores you and keeps questioning. Have they now violated your right?
No, you must declaratively say, I want a lawyer.
Right there. Now, they say you have the right to remain silent. Anything you say can and will be used against you. The flip side of that is if you don't say anything, they can't bring it up. They're not allowed to say, "Oh," and when questioned about it, he just didn't say anything. Right? So, you're sitting there, the police say, so where were you last night? And you just stare at the cop. Can they then in court turn around and say, when we asked him, he didn't say anything?
You should respond, I can answer questions.
No.
No.
You're close, but no.
The police can characterize it as you were being evasive.
No, not exactly. You're much closer than he is. So
could just stay
you're the
calm.
star pupil now. Yes.
Well, you could just stay quiet and they can't bring it up at all.
No.
No?
No, absolutely not.
Huh.
They can say that you stayed quiet. Do you know why?
You're right.
A moment ago, Benny hit on it when it was counsel. You must affirmatively state, I want an attorney. You cannot exercise your right to remain silent by staying silent. You have to look at them and say, I am exercising my right to remain silent. If you simply stay silent, the case law has evolved to say, we didn't know they were exercising that right, so it doesn't apply. Same thing with the counsel. When there's a case out there called the lawyer dog. Who heard about the lawyer dog? What was your understanding of the lawyer dog?
From what I understand, it was someone was requesting a lawyer, but what they said was, quote, I want a lawyer, dog. D-A-W.
Not exactly. Close, very close.
I figured he was your competition at furry conventions.
No.
His name is Buddy Goodboy.
That's Buddy Goodboy Esquire. We're very good friends.
Yes.
Very good friends. The case, that's almost right. A gentleman was arrested in Louisiana. When the police were questioning him, he said to them, I didn't do it, and if you all think I did, you should just get me a lawyer, dog. Okay? Do you think he was asking for a lawyer, dog?
No.
No.
Now, that got appealed up. They said they didn't stop questioning him, and the response was, he didn't ask for a lawyer. got appealed up, the Louisiana Supreme Court looked at it, they decided per curiam that that was the right decision, that he did not ask for a lawyer at that point. Now, per curiam decision at law is very, very simple. It just means that all the justices on the appellate court have looked at the decision and said, we all agree that that holding's right, and we don't have to do an order. We don't even need to hear the case. We are all agreeing, based on the record alone, that is a correct decision. They can do an order, and one asshole judge did one. And I say he's an asshole judge, pardon the language, I just can't dumb that one down. Because when he wrote the opinion, he focused on the words lawyer dog and said something snarky about a legal canine. And it went all over the news. Man arrested, and courts say that he asked for a lawyer dog, not a lawyer. It's not what happened. What happened is, if you think I did it, then you can just get me a lawyer. You take dog out, the holding's still correct. Why? If you think I did it. A conditional statement asking for an attorney, not I want a lawyer. Now, that one was overturned on the higher levels, saying they probably should have been given counsel at that point. However, there are many other cases where that has not been overturned. Conditional statements that indicate you may, but do not definitively want counsel, will not excuse the police from further questioning. They can stop, they can turn around, they can keep going, because you did not make the definitive statement. Words matter. I want to remain silent. I want a lawyer. Better question, though. Why on God's green earth would you walk into a police station voluntarily, sit down, and be interrogated without an attorney by your side? Right? The police do not have time for fishing expeditions. They will knock on your door. They will send an officer to your house. They will call you. That's the main ways they get information. If they are bringing you into the police station to talk to you, and they open with, just to let you know, you're free to leave at any time. You are not free to leave at any time. They are very much looking at you as a suspect for whatever they're investigating, and you need to say, I think I'm going to go now. And I've had clients burned on that before. Well, you told me I wasn't under arrest. Doesn't matter. You're not under arrest. Detention is a very specific set of circumstances. In custody, in a situation where you cannot leave of your own free will. All right. The example I gave earlier, they stop you. They give you a ticket. They say, have a nice day, walk away 2 steps, turn around, and say, by the way, one more thing. It's a very specific legal example, and it's a very special one. Has anybody heard of the plain sniff doctrine? I said plain sight. And plain sight doctrine is very easy. If the police in an area that anybody could be in sees something illegal, they automatically have cause to go forward with the Fourth Amendment. And I'll explain cause here in a second. The plain sniff doctrine is what they tried to apply to a bunch of drug dog cases. The dog smelled it, therefore it's the same as plain sight. Courts have generally struck it down. As drug dogs became more and more used, we had to do something with them. During traffic stops, they were holding people for up to an hour for a canine to come through and walk around the car. At what point did that become unreasonable? The initial stop was reasonable. They had a reason to stop you, right? You were speeding, you rolled a red light, you had a tail light out. So that the initial stop's reasonable. At what point does it become unreasonable?
When they're holding you for that long without actually doing anything.
How long's that long?
I'm sure there's an example, but if it's upwards of like an hour or more.
Well, I mean, DUI stops can take an hour or more if they're trying to determine whether you're intoxicated.
But without they're actually like doing something with you, they're not just holding you. No?
Say you have a car that's reported missing, and they just walk back, they're sitting in their vehicle and they're running everything. That can take 30 minutes sometimes on the side of the road. When does it become unreasonable?
Does it have something to do with the fact that they're getting a canine to sniff out the car without
Very close.
a good reason to get one? It's kind of like moving to a higher stage of a search.
Sort of, but not really. You were fine right up until the second part.
Isn't it because they can't actually search the vehicle unless they have a warrant?
I'll circle back to that and that right after I explain what it is. You look at the type of stop. If it takes 15 minutes to issue a ticket for rolling a stop sign, and they hold you for 45 minutes, after the normal time for that type of stop, it becomes an unreasonable detention. When they turn back around, though, right, after they've handed you the ticket, multiple courts have held, the moment you're handed that ticket and the officer says, "Have a nice day," the detention's done. You can go. When they turn back around to talk to you, though, courts have held that one split second, hand the ticket. "Hey, do you have any drugs in the car?" Just like that, they started a new encounter. And if you continue speaking with them, you have consented to the new encounter. Consent waives your Fourth Amendment detention rights.
Law is a dick.
So like, what if your car, you tried to start the car and get it going, but your engine kind of...
Just look at the officer and say, just a question, and you will never hear me say this again. Am I free to go? Yes?
What if when he turns around and asks you that question about the drugs in the car, you turn immediately say, "I do not consent to any searches"?
Okay. So,
In that case, you make yourself sound guilty and he's gonna
well,
do it anyway.
here's the thing. Technically you are completely within your legal rights to say that, and there's absolutely nothing wrong with telling the officer, "Hey, I'm not consenting to any more of this. I'm done. Can I go?" Okay? And the officer's mind, what they hear is, "Huh, really?" And now they're looking for a reason to keep you there. Or they just start talking, "Oh, well, I didn't ask to search you, man." "Okay, well, I'm just letting you know." "Yeah, why would you come out with that?" And what they're doing is they're asking these questions to form reasonable suspicion and probable cause. What are they? I told you what the Fourth Amendment was. No unreasonable search and seizure without probable cause. Okay, probable cause rises to the level of the police don't think there's something criminal going on. They pretty much know. Right? They're pretty certain there's something criminal going on. It still doesn't waive your Fourth Amendment rights. They still have to get a warrant. But when you have probable cause, you can stop and detain somebody. You can do telephone warrants. I've seen those come in where they call a city magistrate and go, "Hey, I've got so-and-so on the side of the road here, and I need you to issue an arrest warrant or a search warrant for their house, not the car." All right? Reasonable suspicion. Terry v. Ohio. Thank you, Ohio. It's sort of an abrogation of your Fourth Amendment rights because it allows the police to stop you long enough for an investigatory detention. It allows them to stop, ask questions, look around, and determine whether something is criminal. All right? This is, you heard about in New York, the stop and frisk. Where they were walking up to him and, "Hey, come here," and patting you down. That's what we in law call a Terry stop. It's them stopping you in a situation where they have reasonable suspicion of criminal conduct to determine whether or not a crime is being committed. The Terry case is actually really interesting. The Terry case was some officers in Ohio witnessed somebody acting really suspicious around a bank. They stopped them, they asked them questions, and patted them down and found the gun that they were getting ready to use to rob the bank. Their lawyers came back and argued that is a Fourth Amendment search and seizure. The seizure part is you're stopping me, you're detaining me. The search part is you're patting me down, you're frisking me. The court came back and said, under those circumstances where it's not too invasive, we will allow the police to stop you for a short period of time for purely the purpose of investigation. All right? If they ever do that to you, pray to God you have nothing illegal that feels illegal in your pockets, because if they feel anything of an illegal nature, they can proceed. Now, you said they have to get a warrant to search your vehicle. Who in here would believe that they have to have a warrant to search a vehicle?
Not when you ask it like that.
Sure, I do.
Here's a good chunk of law for you. Your right to a warrant, to have a warrant done, where they have to have probable cause, which is the standard, by the way. That is the standard. It's not probable cause based on their determination. They have to enunciate that probable cause to a judge who signs the warrant. That's how that works. Okay? But it is based on your legitimate privacy interest in the property to be searched or the thing to be seized. Okay? Houses. Your house is the highest threshold of that privacy interest. Your car is not. The cabin of your vehicle, within your arm's reach at the very least, is almost always going to be subject to police search, as long as they have reasonable suspicion of criminal activity. Okay. That is the constitutional standard. Now, little known fact, states can give you more protection than the U.S. Constitution. They cannot give you less. Where I practiced Pennsylvania, up until 3 years ago, they did have to get warrants to search your car. Then a case came down and flipped that on its head. And said, no, not anymore. Okay? Things that can be seized unreasonably from you during a detention, your blood. We had a United States Supreme Court case recently where mandatory blood draws that carry criminal and not administrative penalties for DUI were unconstitutional. You can't force someone to incriminate themselves, and you can't seize their blood without a warrant. So without getting a warrant for a blood draw, any penalty that gave you an increased criminal penalty, not administrative penalty. You get pulled over for DUI, don't drive drunk. If you get pulled over for a DUI, and they say, if you don't consent, you're going to lose your license for a year. That's fine. That's what we call an administrative penalty. It's not a criminal penalty. If they say, if you don't consent, your license is going to be suspended for a year, and it's automatically a highest grade DUI that carries a mandatory 60-day jail term. They can't do that. They cannot condition the severity of your penalty on whether or not you have waived constitutional protections. A lot of cases got thrown out, and a lot of police departments are now moving away from blood draws. Why?
Too hard to deal with it.
What else is the other option? You get stopped for a DUI. How do they test you? Breath or blood?
Plus, yeah, red towel. I mean, there's the
Anybody? I'm not gonna ask you to out yourself here. But if you've had a DUI and you've had to do a breathalyzer, you know they don't ask for a warrant before they do them, right?
Right.
Correct.
They still don't. They can make you blow into that breathalyzer, and they can give you an increased criminal penalty for not doing it. Why can they do that with breath but not blood?
Because you're breathing all the time, you're not spewing blood everywhere all the time?
Close. Invasive. Remember how I said the severity of your legitimate privacy interest in the property to be searched or the thing to be seized. Your breath blowing into something is not as invasive as taking you to a hospital and sticking a needle in your arm and running a test. That's what triggers the higher protection. Now that I've finished that part.
I have a
Yes.
query about that. This is something that always has been on the back of my mind. In the course of my career, I routinely work with a particular chemical which in my body will cause a positive breathalyzer test.
Okay?
Can I use that as a defense?
You certainly can. You certainly can. Okay.
But don't go out and get drunk.
Here's how it works.
Not that I plan.
Take a look at your DUI laws. And now I'm doing something one of my law school professors did. I'm just going to walk through you as I'm talking. It's going to really piss off the kid. I encourage us, take a look at your DUI laws in your state. Take a look at all the laws in your state. You're not going to understand them, but they're a fascinating read. Did you know in the Commonwealth of Kentucky you cannot dye a baby chicken blue and sell it?
I did know that. Laws like that are hilarious.
It's not even animal cruelty.
It's not?
Somebody said it's not animal cruelty. You know what it is? Adulteration of livestock sales. You cannot sell artificially dyed baby chicks or rabbits in the Commonwealth of Kentucky because you can dye them to a more preferable fur or breed plumage and sell them as a more expensive type. It has nothing to do with animal cruelty. It has everything to do with agricultural commodities. Yes?
Do you happen to know if that law was based off of an actual incident involving?
It was based off of several actual incidents.
That makes sense.
It's illegal to fish from camelback in Florida.
Oh, jeez.
As I was saying a moment ago, read your laws. They're amazing. But like in that situation with the DUI law, here are the bases. We have per se intoxication. Every state has per se intoxication. What's the legal limit to drive? It's the same answer for all 50 states. So God, I hope you know it. The legal limit to operate a motor vehicle is 0.08. Okay? 0.08. That's the legal limit, right? Everybody knows that.
Yeah.
What's the legal limit to drive?
Oh.
1 beer. 1 beer, 1 toke of marijuana, 1 nanogram of a metabolite of any Schedule 1 narcotic in the Commonwealth of Pennsylvania. 1 nanogram.
Damn.
So low that if you were in the same room with someone smoking a joint, you have a chance of being convicted of driving under the influence. What does .08 mean? The way the laws are written, and it's this way in pretty much every state, either a separate offense or part of the DUI offense. Anything that substantially affects your ability to operate a motor vehicle. If 1 beer gets you so drunk that you cannot safely operate a vehicle, congratulations, you can be convicted of a DUI. Okay? The .08, the 1 nanogram, all that, those are what we call per se offenses. All right? If you get pulled over and you blow a breathalyzer and you blow over a .08, nothing matters. It doesn't matter if you seem impaired. It doesn't matter if you're driving perfectly. None of that matters. You are impaired as a matter of law. Unless you can show the breathalyzer's malfunctioning, unless you can get the evidence thrown out somehow, unless you can show it wasn't tested, or it's not one of the statutorily defined breathalyzer types that they're allowed to use, you are guilty. It does not create what we call a rebuttable presumption, meaning, well, yeah, they blew over it, so we're going to assume they're doing it, but we can show evidence that they're not really impaired. Pretty much every state has struck that down. It means you're guilty. It's a per se offense at that point. 1 beer, though, lots of people have 1 beer and drive, right? That's what requires the state to show evidence of actual impairment. And that's where you come in. You work with a chemical that will cause you to pop on a DUI test almost any time they issue it, right?
Yes.
So you present that evidence. I have not ingested any alcohol. This is a chemical matter. And the court may say, okay, we're going to say you're not per se. Because this is something you work with. It's a documented effect. We know. The state goes, okay, well, we understand that, but Dr. Conway, how do you explain this video of you pantsless reciting your ABCs in random order? When we told you to touch your nose, you grabbed your hair, yanked it back, and said, "Spank me, Daddy."
I cannot grab my hair.
I was going to say, falsified evidence. Objection. When they take you out of the car and they have you do the roadside test, you know that everybody says, "Oh, I passed the test." You know this.
Finger to the nose, walking the
You know.
miss.
1, 2, 1, 2. You know, follow the pin with your eyes, all that stuff. It was like, I passed it with flying colors. A, no, you didn't, and the videos are hilarious.
It's hard to. What's this? Is this?
B, it's not a pass-fail test. Those came into play, and especially with the rise of dash cams, those came into play, so that there's documented evidence of the fact that you could not perform simple operations competently. So even if their breathalyzer gets thrown out, even if you blow a .04, they have evidence of you stumbling back and forth all over the place, and they say, this person can't even walk. Are we honestly going to say they're not too impaired to drive? The whole reason that we have the per se DUIs with the breathalyzer, the blood testing, is Mothers Against Drunk Driving. The state has to prove in a criminal matter every element of an offense beyond a reasonable doubt. It is the highest single standard at law. Beyond a reasonable doubt. All right? The idea behind a reasonable doubt, very simple. So simple that we've never been able to define it. I'm not joking. When you start doing criminal work, the very first thing you learn from your professor, your mentor, your law partner who's shepherding you through your first trial is you will never be able to adequately define the standard beyond a reasonable doubt because no legal definition exists. Preponderance of the evidence, well, the evidence is more heavily weighted on this person's side, so they find it. Clear and convincing evidence, the evidence, when you look at it, is so clear that as a matter of law, the ruling must go that way. Beyond a reasonable doubt? I used to use what I called, on the defense side, or on the prosecutor side, the pink elephant explanation. The pink elephant explanation is, ladies and gentlemen, the standard in this matter is beyond a reasonable doubt. It is not beyond any doubt. It is a question not of possibility, but probability. It is possible a pink elephant could fall through the roof of this courtroom. Under the right set of circumstances, a zoo transport carrying pink paint and one baby elephant could be flying above. It could hit turbulence. The paint could come loose, completely coat the elephant. The C-130 could then have a malfunction. The bay doors could open. The elephant could fall out, hit an abnormally strong upgust that prevents it from dying on the way down because we're not into animal cruelty. Slam through the ceiling of the courthouse, down through 13 floors, and land unharmed in the middle of this courtroom under the right set of circumstances. It could happen. It is possible, but it's not very probable. And that's the standard of beyond a reasonable doubt. It's not beyond any doubt whatsoever. It is. Under normal circumstances, all facts taken as equal, the only reasonable explanation is they did it. That's the only reasonable, not the only possible, reasonable. And under that standard, we've met the evidence. And then I get cute at the end and I say, by the way, I don't see an elephant in the courtroom, and the judge yells at me. So, there's guys who use the cake explanation to do it. You know, you have a toddler in a room with a giant cake. There's one entry and a window. And you say to the toddler, hey, don't eat the cake. I got to make a phone call. You step out of the room, you come back, the cake's gone. Did the toddler eat the cake? Well, maybe somebody else came and ate the cake, right? That's not unreasonable. All right? Okay, so now I have to prove one exit, one entry. I'm standing right outside the entry, and I testify nobody else left the room. Nobody else entered the room. It's just the toddler in the room, and now the cake's gone. Maybe that's enough. Toddler says, there's a window. Somebody can come in the window. Okay? I'm standing outside the door. There's a window, but the window is nailed shut. Nailed it shut 20 years ago. There's no way it can get open. And when we looked afterwards, the nails were still in there. Somebody ate the cake. The toddler's the only one in the room. Did the toddler eat the cake? I have a dog. The dog's under the table. Dog ate the cake. The dog's dead. I'm standing outside the room. The windows, we sent the dog to a farm upstate last week. Timmy, we just didn't tell you. Or better yet, a better example of that would be, then Timmy says, well, the dog came back from the farm upstate. Oh, Timmy. But the idea, you can see how it's building there. At the beginning, yeah, there's reason for that. Somebody else could have ate the cake. Just because the toddler's in the room doesn't mean the toddler ate the cake. Well, nobody else entered or exited the room. Okay, well, that seems a little strange.
What if we're talking about your toddler?
My toddler would do some Mission Impossible stuff. Kids drop it. And he definitely ate the cake. Yes?
I mean, it is very possible that someone did, I mean, he's not lying when it says there is a window, because someone could probably crawl through the window, ate the cake, then crawl out and close the window just to make it seem like nothing
But
ever
it's
happened.
nailed.
But it was nailed. Did you get that bit?
I want you on a jury. No, I mean that. There's the other part. Justice. All right. We have probably the best, and I hate to say this, the best functioning criminal justice system on the court level in the world. You may not agree with me. You have not been in some of the other systems. Okay? In theory, our criminal justice system is very fair, very honorable, and very nice. In practice, it's not. Okay, I'm just letting you know right off the bat. I'm not sitting here going rah rah rah. Everybody pat me on the butt. I'm a lawyer. Because it doesn't work that way in practice. But in theory, it's one of the best systems in the world. But I want you on a jury, and I want you on a jury for one reason only. If I've got somebody on murder and I can make an argument like that to you, okay? I know I'm not going to win. I know, best case scenario, I'm going to hang the jury. I'm going to make them retry the case. They're going to get somebody who doesn't listen to my crap. And my client's going to get convicted. But you know what it does to me? It allows me to go back to the day and go, look, I hung the jury once. I can hang them again. I can keep hanging them till the end of time. Because you need all 12. I need one. Why don't we cut a deal? And if you think that that's not how it works, I've done that multiple times. Yes?
The matter with the toddler, there's one. Because I'm trying to put myself in the mind of your toddler. Your son would certainly say, can we establish there was a cake here to begin with?
You joke, but that's actually a defense. Is can you prove it was there to start with? These are the words corpus delicti. Okay, do you know what it means? The body of the crime. These are the words habeas corpus. Do you know what it means? Present the body.
Yeah.
Okay. Corpus delicti, the body of the crime. So, and this is a common misunderstanding. If you murder someone and they can't find the body, they can't convict you because they can't prove the murder. Okay, no. The body of the crime simply means the facts and evidence that indicate the crime has been committed. Okay? It used to be really difficult to prove there was a murder if you didn't have a body. And the reason it used to be really difficult to do that was because people moved a lot more in the 1800s. There's a serial killer out there. No, not now, hopefully, because it was like 150 years ago. So I'm really hoping he's dead. But there was a serial killer out there who killed over 45 women. It wasn't like he was operating in shadows. He was going into towns, establishing a house, meeting the women, dating them, telling people his name, getting business, marrying them, staying married for several months. Then he'd kill them and take their money. Everyone knew what he looked like. Everyone knew what his job was. Everyone knew where he lived. They at least had one of the, I think, 20 different aliases he used. How did they not catch him? Because it was the 1830s. And after he realized he was under suspicion for their deaths, he would leave town, change his name, and go 4 states away. So it used to be really, really hard to prove a crime without having the body because people move too much. So the argument would be, you can't prove they're dead. You could have just gone to Texas. By the way, I'm not joking. The further west you go, you'll see a lot of cases from that time period where the argument in defense is, we didn't kill him, he moved to Indian territory. And I've got 5 witnesses that I drink with every night down at the bar who will say that he walked in 2 nights ago and said, you know what, boys? I'm going to cut myself, bleed on the floor, and move to Indian territory with all of my money. Why do we let that happen? When you know someone's guilty, you look at him. Casey Anthony. Why do we let Casey Anthony walk free? Every right-minded person in the world took a look at that and said the same thing. She obviously had something to do. Maybe she didn't kill the kid, but she obviously had something to do with it, right? Right? Why do we let her walk free? Everyone knows. Why? It's a real question. I'm looking for a hand. All the way in the back.
It's not what you know, it's what you can prove.
That's one part of it.
She had something to do with it, but you can't say what that was.
That's another part of it.
I have a hand. I don't have an answer, but I have a hand here.
Thank you. You win the pedantic award.
Yeah. Hear that? I want an award.
Here's where we start moving into the second part of this, where I kind of explain how our law is. Now, I've been doing that to the criminal nature. I always say I'm not going to talk about criminal that much, and then unless somebody says, hey, Boozy, you said you're not going to talk about the criminal side of it that much, I spend half the time on the criminal because you guys like the bloody stuff.
Yeah.
Like, I do have one civil law example I'm trotting out because I love it, but our laws laws in this country, with the exception of Louisiana, because as we established from Lawyer Dog earlier, Louisiana's messed up, is based on English common law. The English common law evolved over hundreds of years. They were court decisions. There was no book of law. Okay? There was, this is right, this is wrong. We have determined that over court cases, over centuries, and we look back at our prior opinions to determine how to handle these things and what is a crime, what isn't a crime, what the offenses are, what you have to prove. Hundreds of years. In the 1700s, they began to start codifying English law, and a little bit before that, the reason they started to codify English law over there was a gentleman named William Blackstone. Blackstone was probably one of the first English common law historians, and that he created what are called Blackstone's Commentaries. It was a multi-volume collection of all of the major landmark cases of English common law that set standards that, to this day, we follow. When you study law, you study cases. You don't sit there with the book of law, because A, it doesn't exist. Like you have statute books. B, the cases are what you're going to argue, how the statutes have been interpreted over time, even when they're there. Blackstone collected all these landmark cases. They went out there. Blackstone's Commentaries. It is the foundation of the American justice system. And in Blackstone's Commentaries, there is a wonderful line that was later paraphrased by Benjamin Franklin in relation to criminal law. It is better that 10 guilty men go free than one innocent be punished. That is the standard. That is why the burden's on the state. That is why it is so high. Because we say it is better that we let 10 guilty people go free. Even though we look at them, we say, oh, you definitely did it. If you can't convince a jury of that same fact, we say, go on, get out. To avoid the risk of punishing one innocent person, or that's how it's supposed to be. As I said earlier, how it works technically and how it works realistically are two different things. And I'm not here to argue the politics of it, because, trust me, I can. All right? So the English common law develops into the American legal system. We develop it over our own. We write our own statutes, okay? Does that mean the common law is gone? Absolutely not. We use common law every day. All right? We have statutes, the written laws regarding crimes that you committed, the Uniform Commercial Code, what contracts must be in writing, things like that. We have those. Those are written legislative laws. They're not common law. But a contract matter? You sue Bob because Bob said he was going to sell you a car and he didn't sell it to you. Look through your laws. There's nothing about it. Why? Because we have hundreds of years of precedent. And that's what we refer to now as the common law here in America, and where it's something particularly settled. What is a contract? Offer, acceptance, consideration. Those are the three basic elements of a contract. An offer for something, acceptance of that offer, and payment of consideration. It's much more complex than that. They teach entire courses on it. But those are the basics. That's what we call black letter law. All right? This is how it is. This is how it is everywhere. It doesn't change anywhere. Now how you interpret what is an offer, when is an offer rejected, then you have to look at the case law of where you're at. So in this part here, which I think I had, what, like 10 minutes? Yeah, about that. We're going to talk very quickly about the law of contracts, because that's why I like to spend a lot of time, and I never get to, because I talk about the bloody stuff. Number one, how many of you, and be honest, have just looked at a contract and said, yeah, looks fine, and signed it? I hate all of you!
Terms and conditions on phones, come on.
I accept the terms and conditions.
Read your contracts! You don't know what it says! Somebody's like terms and conditions on the phone. You guys know how I Twitch stream? Yeah, somebody sent me Resident Evil 2. You know what I did for the first hour of that stream? I read the terms and conditions! Because you didn't live stream. I'm responsible!
That's not the point.
Does anybody in here know what a confession of judgment is? Have you ever heard the words before? Nope. Oh, this is how I get you to read your contracts, by the way. All right, so you sign a contract, right? And say you breach it. Yeah, you're just supposed to make payments. You can't keep up. You figure, well, they'll give me time to get caught up, and if not, the worst case scenario is they file a lawsuit, and then I can negotiate with them and I can get it down. All right? Then you come home one day, and the sheriff's nailing a sheriff's levy paper to your door, and you haven't even received a notice of lawsuit's been filed against you. Which, by the way, real quick, public service announcement, they don't do court process over Facebook, YouTube, Twitter, or your telephone. Nobody does. So don't give those assholes who, pardon me, say a lawsuit has been filed against you unless you pay us this amount of money. Don't give them anything until you get a piece of paper. Okay? And side note, the IRS will never call you. You call them. The IRS only communicates via letter. All right? So, just 2 public service announcements real quick on that. Yes?
If they did do it via Facebook, Twitter, YouTube, etc., then there could pretty much be some very biased...
Actually, I shouldn't say that, and I'm going to explain real quick why, and I'm really loath to do it because it's going to negate something I just said. Courts have authorized service of legal process via Twitter.
Oh, shit. Wait, what?
There is something called a motion for alternative service where you can't get service on somebody on a complaint, which you have to get. Any other way, we can go back into the court and go, this method is reasonably constructed to give them notice, and we would like the court's permission to do it this way this one time. And there has been at least one instance of a court saying, well, they're dodging the process server, and we don't know where they are now, but we know they're tweeting every hour. So yeah, we'll let you tweet them a link to the lawsuit.
Wow.
It's happened at least one time. Now,
did he have to click the link? I have to know.
yeah, it doesn't matter. If I hand, that's the other thing. Process server, you'll hear like, oh, it didn't touch me, so I'm not sure. It's not how it works. But, are you alkali?
No.
Let's try this. Hey, are you alkali?
No.
I've got $100. Are you alkali?
Holy shit! Twice!
Okay, I have a court action here for you.
Didn't touch me!
Doesn't matter.
It touched the ground, that's illegal.
Then they'll go back and they'll go, confirmed, provided, left. File it with the court and you've been served. Doesn't matter whether you ever pick it up and read it. You've been served. Okay? Now back to what I was saying though. You come home and there's a sheriff nailing a levy order to your door. The sheriff's going to take all your crap and sell it. Is that okay? You've never received a lawsuit. You've never been served. And now they're saying they have a judgment.
Sure doesn't seem okay.
Confession of judgment. It's an archaic process. It doesn't apply in very many states anymore. It still applies in mine. And where they use it, it's heavily restricted now. But a confession of judgment is part of a contract. Or can be part of a contract where it's allowed. And there's a statement that you are signing that says, by the way, if I default on this agreement, your lawyer gets to go to court, enter a complaint, and confess judgment on my behalf. And they get a judgment against me immediately. And you can act on it. It can only be done where it's still allowed, which, like I said, not very many places anymore. But where it's still allowed, it can only be done by writing that has been acknowledged, giving them that right. So where do you put them? Paragraph 16 of the contract in bold type and uppercase letters, the whole thing, with a little initial box. And then they say initial here, and you initial it without reading it, and you sign at the bottom. And then if you run into financial troubles, you go to the bank to get gas, and you find out your account's frozen and everything's been sent to your judgment creditor because you authorized them to take a judgment against you without a lawsuit.
What states is that in?
Right now, New Jersey, Pennsylvania.
Damn it.
I'm not sure if Ohio has it still. New York still has it.
Michigan does, but it's heavily restricted.
Yeah, Now, and like I said, it's restricted even where it is now. Like in Pennsylvania, if you're a consumer with less than $10,000 of annual income, I cannot confess judgment against you. I'm not allowed to. All right? It's mainly for companies. But states do allow them against consumers too, where they're allowed. You know what would have prevented it? Reading the contract. Seeing a clause that said confession of judgment that contained the words enter judgment against me without action, because they almost all of them have to have that language in it, and say, I should really have a lawyer look at this before I sign it. Alright? Read your contracts. 9 times out of 10, if you read them, you can avoid the problem. But Boozy, I'm buying a car that I have to get to and from work. How can I avoid it if I have to have it? Go to a different car lot. I'm renting an apartment. Okay? A, be familiar with your landlord-tenant laws, because there's a lot of non-voidable and non-waivable protections in those landlord-tenant laws in most states. B, read your contract!
Also make a copy of the contract.
Definitely.
Yep.
Oh, yeah.
Nothing aggravates me more than hearing, I didn't keep a copy of this.
Oh, God.
One last thing, and the only reason I'm going to say it right now is because we're coming up on the end of the time, and I always like to get this one out on the civil side, because I spent way longer on the criminal stuff than I normally do. And it is about warranties on contracts. Right? You'll see no warranties, no express warranties, things like that. Right? Do you know why that's there? Okay. Now, this next part, I have to say, not legal advice. Please consult a lawyer in your jurisdiction. Almost every jurisdiction has what they call implied warranties read into contracts, okay? One of the implied warranties is a warranty of merchantability and a warranty of fitness for a particular purpose. And the implied means they don't have to be expressed in there. Every single contract has them. The warranty of merchantability says, I am warranting that this good, what I'm selling you, is appropriate for reasonable, typical use of this nature. Okay? Nothing else, just that it's appropriate for it. Doesn't mean that it works perfectly. Doesn't mean it won't break down 2 months from now. Just means I'm not selling you a fork that's made out of lead and cyanide that you can't eat with. Okay? Warranty of fitness for particular purpose is a little bit different. That's where you tell somebody, hey, I'm going to use this thing for X. They know that, they sell it, and they know that it's not good for that purpose at the time that they're selling it to you. Okay? Don't try to get around that by saying, like, I was going to use this car to live in, and it's a fucking Volvo. It's not going to work. Okay? But, you know, something like, I need a plywood that will stand up to adverse weather conditions for my roofing project, and they sell you some paper-thin stuff that melts when water touches it. That's a warranty of particular purpose claim. So when they do that, they're not disclaiming those, they're read in. Now, go back to the car sale. Right? They sell you a car, you get it off the lot, engine blows up. Okay? Engine blows up, you take it to a mechanic says, that engine's been cracked for 7 months. Shouldn't have been sold like that to you. You have a suit. How so?
They sold you a car that they said would work.
I didn't say they said it'd work.
It was
Lemon law almost never applies to used vehicles.
Really?
Check your state laws. Lemon law almost never applies to used vehicles. It is specifically for new vehicles. And this is why, right here, unless your state requires they do intake to know of conditions with it, a used car dealer is not really making a warranty to you unless they expressly say it. All right? If I'm selling you a car, and I say, this vehicle has absolutely nothing wrong with it, we went through the engine's fine, runs like a dream, go forever and a day. Okay? You drive it off the lot, engine blows up, and they say, that engine had condition for 7 months. Yeah, now I'm liable. I've made an expression to you. The engine is fine. We've gone over it. If I just say, runs like a champ, will go forever and a day, and you sue me, that's probably not going to work because courts have said that that's not a statement of condition. That's what we call puffery. Mere puffery is the term you see. I'm using this to try to get you to buy it, but I'm not making an expression to you. So say you buy the car, you drive it off the lot. I've said the engine's got a couple problems, but it probably fixed pretty well. Okay? And by the way, if they make that statement without knowledge that they otherwise would not be obligated to have, not liable. Just, engine runs forever and a day, No problems with it, never have been. You drive off, maybe then I'm liable because I said never have been. But I go, as far as we know, absolutely no problems with it. We haven't taken it to a mechanic. He said, well, you told me there were no problems with it. I said, no, I said as far as we know, there's no problems with it. But we're not obligated to find out. That's probably not a liability situation. Driving off the lot, there's a couple issues with it. You're fine. You get down the road, you turn on the radio, you open up the air vents, you're listening to some Gordon Lightfoot, and then bees fly out! Just a swarm of bees from the air vents stinging you as you swerve all over the road, screaming! You take it in, and they go, there's been a hive in the air conditioning unit for 3 years.
Should have checked the contract for bees clause.
Do you have a lawsuit? Probably not.
No.
Unless they knew about it.
What if that happens and you hit someone?
Congratulations, you have negligence. We're not getting into it this one. The concept is reasonably foreseeable. Would the car dealer think it was reasonably foreseeable that there would be bees flying out of the air vent? Did the person do anything to notice that there would be bees flying out of the air vent and neglect to tell you? Are they required to disclose it? Does it fall under the reasonable portion of reasonably fit for on those applied warranties? So, to summarize, bees are probably not an issue. You're not going to be able to sue on that. If they tell you the engine works fine, it's limited to the extent of their knowledge and their due diligence, a requirement to know. If they make an express statement to you, this is like that, and you find out that's later, that's actionable. All right? So listen to what they're saying. How will you know that? You don't. And that's what wraps up the whole thing. Basic law is wonderful. Everyone needs to be educated as to it. You have to know how these things work, how they operate. But it's not giving you knowledge to actually go into the details of it and determine where you stand in relation to these things. A criminal matter, what you said to the police, a good or a bad thing, where you obligate to say, did you say the right thing? Is it a detention? Is it not a detention? Do they have sufficient evidence? Can they meet reasonable doubt? What's a good offer? What's a bad offer? What's the sentencing guideline? What does this contract clause mean? Hey, when they told me the engine ran, is that like an actionable statement? Can we sue the bees?
Or at least the hive where they came from.
Those are the questions you have to hire an attorney for, because that's what we do. Okay? I haven't seen the bee case yet. I want to see the bee case. So, please, for the love of God, no matter where you live, if you buy a car and a swarm of angry bees spew forth from the air conditioner vents, call me. I will wave into your jurisdiction to take that case. I didn't get to cover everything I wanted to, but I have Porter over here waiting very patiently for me to shut up.
You're fine. I'm learning new stuff.
So everybody wave to Erner.
Hi.
Erner, what's your panel?
My panel isn't here. It's as soon as this man shuts up and gets the hell out of my room. My panel is Erner's Hardcore History Hour with Uncle Kage.
There you go. Hang around for Erner and Uncle Kage, folks, and thank you very much. I'm Boozy.
Thank you, Boozy.
I can promise you my panel will not be nearly as educational as this, but it will be at least marginally entertaining.
You're good.
Silver Gato Man, he bought me a coffee. Silver Gato Man, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gato Man, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.